Good morning, everyone. My name is Margaret Fieldbinder, and I am the host for this morning's webinar on behalf of Diversified Insurance Solutions, a division of Associated Benefits and Risk Consulting. I'd like to welcome you all today, and thank you for joining us this morning to hear the latest tips and trends in leave management and reasonable accommodation. Before we get started, I just wanted to run through a quick few housekeeping items. First, everyone is currently muted in listen-only mode. We have a lot of great content that will probably take us the full hour, so this will help us keep to our designated time frame. We love and certainly encourage questions, so please feel free to type them in the questions box throughout the program as we reserve time at the end of this presentation to answer them. But if for some reason we don't get through all the questions or we run out of time, we will send you a Q&A document with all the questions that were asked during this webinar along with the answers, as well as a recording of this webinar and a copy of the presentation. It's my pleasure to introduce you to this morning's speaker, Catherine Weber. Catherine is a labor employment attorney based out of the Cincinnati, Ohio office of Jackson Lewis. She is extremely knowledgeable in leave management and reasonable accommodation requests. She advises a broad range of employers when law matters arising from under the federal and state law. In addition to her counseling and litigation duties, Catherine frequently provides training and seminars such as these on how to formulate and enforce effective personnel policies to avoid and minimize employee lawsuits. She's appeared numerous times on nationally syndicated radio talk shows, has published articles in state newsletters and magazines, and serves as the chairman of the board of directors on the Employers Resource Association, a Cincinnati-based organization providing 3 companies in 3-state area of HR advice, training, and updates and legal issues. With that, please join me in welcoming back Catherine Weber.
Thank you so much, and good morning, everybody. So today we're going to talk about an issue that is near and dear to my heart, trends and tips in leave management and reasonable accommodation. And as Margaret said, I'm an attorney with Jackson Lewis, and we are a labor and employment management side boutique firm. What that means is all we do is management side defense in the area of labor and employment law. So if it has to do with your employees, we can help you no matter where you might have a location. So you can see from the next slide that we have roughly 850 attorneys spread across 58 offices throughout the country. We also have an affiliation with a Hawaii-based firm. And you know, the fun thing about working at Jackson Lewis is it allows me really, and those like me, to do nothing but what we love the most, which is labor and employment law. So this is a topic, and particularly when we get into the ADA, the FMLA, leave management issues, this is a topic that I could talk all day on, but don't worry, I won't. We'll only spend an hour on it. So let's get started and talk about what we're going to discuss today. So within Jackson Lewis, we take labor and employment law and we cut it into slices. And there's one particular slice within our labor and employment law group that's called disability leave and health management. And those of us who practice in this particular space, we focus a lot of our attention on ADA, FMLA, leaves of absence or requests for accommodation arising out of state laws. Maybe we've got a situation where somebody's been injured on the job, and so there's crossover between an ADA question and a workers' comp question, or perhaps, you know, it's some other form of a request for time off work that might not trigger a federal right, but could trigger a state law right. So this is a wonderful space for us to talk about today. We've got plenty of great tips to share with you because what I've done is every year I basically gather in the hot issues that a lot of people are dealing with within our practice group, and I created this PowerPoint for you so that you can get the benefit of hearing what it is that we're currently dealing most with in this space. So first, I think you need a little bit of perspective, and I think people just forget this. You know, the Americans with Disabilities Act came out in 1990. Think about how long ago that was. And then we had the Family Medical Leave Act of 1993, and after that, we had the ADA Amendments Act of 2008. And I'll tell you a little funny. When I was butting up into to 1993. It was probably the end of 1992, and we were all looking at the Family Medical Leave Act going, oh my gosh, there's 3 inches of regulations to learn and digest and to create policies for the law firms so that our employees know what their rights are. Who in the world can we ask to do this? And everybody in the firm looked at me and said, give it to Catherine. She doesn't have a maternal bone in her body, man. She'll love this stuff. Well, the joke was on them because I now have 4 kids, most of whom are nearly grown. But so I had the opportunity to learn the Family and Medical Leave Act and the ADA from its very inception, read everything that there was to know about it. And so that really has given me a different perspective than folks that are relatively new to the practice. Now, I think that we'd be remiss if we didn't talk not only about the ADA, but to also let you know that there is this trend, and I'm sure you're aware of this, that different states and different counties are enacting paid sick leave laws. And you don't have to be disabled in order to take advantage of one of these paid sick leave laws. But what many employers miss is, let's say I'm a Cincinnati-based company, and I have employees, let's say in Oregon. So if that's the case, I need to be aware of the fact that Oregon has paid sick leave laws. And so I need to know what those laws are in the event that my employee in Oregon requests time off. So what I've given you here is a nice map of the United States. And where you see green, that means that particular state has a paid sick leave law. Where you see yellow, that means that there is a local paid sick leave law. And where you see red, that's what we call a kibosh state. And in a kibosh state, what has happened is that the state has enacted a law that says none of the municipalities, none of the counties, none of the cities can enact their own special breed of a paid sick leave law. If there's going to be one, we at the state level will enact one. And that's really wonderful because, it's terrible for folks when they have to comply with so many different paid sick leave laws all within the same state. And sometimes they're only a couple blocks away. So, it would be easy if we had one paid sick leave law that covered everybody, but we don't. And so each of the paid sick leave laws has their own approach to handling paid sick leave. They're similar in their approach in that they'll all define how many employees you have to have in the jurisdiction in order to be covered, but they'll all have very different ways of determining whether somebody works in the city or works in the locality. All of them will have an accrual formula. Some will say 1 hour of paid sick leave for every 40 hours worked, or perhaps less. There will be some common reasons why people can take paid sick leave. For instance, if your family member is sick or you're sick, or maybe, there's a domestic violence or a sexual assault. But then there are other outliers that even include things like you need time off in order to take your service animal in for some sort of a medical appointment. Each of the paid sick leave laws will have different approaches to notice requirements and what kind of documentation you can ask for in order to support the request for time off. They'll all be very different regarding whether they require carryover, whether or not you have to pay people out. There's a whole host of issues that unfortunately are very different from jurisdiction to jurisdiction. So if you have a client, you have an employer, you are an employer, who has employees in various states across the country, you have to be painfully aware that there could be paid sick leave obligations that apply to those employees. So for those of you who have heard me speak before, you know that I always follow a 3-step process anytime I'm analyzing whether or not somebody is entitled to time off work under the ADA or under some other federal law. Now that we have paid sick leave, I've modified that rule a little bit. So the first thing that we ask ourselves is the employee entitled to be absent with job protection? And, we would look at the family medical leave first, and then we would look at state and local leave entitlements. So that might include things like these paid sick leave laws. Then we ask, has the company committed to providing additional job protected leave, perhaps in a policy or in a promise? Then we ask whether or not the leave is required as a reasonable accommodation, either under the Americans with Disabilities Act or perhaps under the Pregnancy Discrimination Act. And, it's really important to keep in mind that for those folks who have employees who are off work receiving short-term disability benefits, or maybe they're off work because they were injured on the job and they're receiving workers' comp benefits, those folks are almost always going to be considered disabled under the ADA. The second trend really that we're seeing is that in some cases, employees are trying to claim that they're transgender and therefore they're entitled to some sort of an accommodation under the ADA. So let's look at an example of how that might come up. Here's a fact pattern for you. So Bruce is an instructor at a fitness club, and he complains to you that he has gender identity disorder, a condition in which his anatomical sex at birth doesn't match his gender identity. According to Bruce, the GID limits the major life activities of reproducing and interacting with others, which causes related significant stress and anxiety. Bruce is in the process of having his name changed to Caitlin, and on Monday will begin consistently presenting as a female. Bruce requests a name tag showing the name as Caitlin, a female uniform, and permission to use the women's restroom, all as a reasonable accommodation for his GID under the ADA. I know that sounds like a lot of alphabet soup, but hang with me here. So the question is, do you have to accommodate Bruce's requests under the ADA? So here's how this works out. Under the ADA, there is a specific exclusion for certain types of disorders. And one of those is gender identity disorders not resulting from physical impairments or other sexual behaviors not resulting from physical impairments. Now, you might say to yourself, really, Catherine, does this issue come up? It does. And in fact, we have a case out of a Pennsylvania federal court using the same fact pattern. And in May of 2017, that particular court found that although gender identity disorder is excluded under this particular portion of the ADA, if there are other related medical conditions like stress and anxiety, then the employee could still be protected under the ADA, and therefore the employer would still have to go through the interactive process in order to determine whether a reasonable accommodation would be appropriate. So this is important to keep in mind, and also keep in mind that some states and local laws have broader laws than the ADA and broader laws than even Title VII that would provide protection under this type of scenario. And regardless of whether you're concluding that, yes, there is protection under the ADA or no, there's not, you still have to consider whether or not there's a Title VII or a federal sex discrimination claim lurking if you fail to go through the transition process with this particular employee. Now, if you're asking yourself, so what's the answer, Catherine? Do I have to go through the interactive process? Well, if you look back at the fact pattern makes clear that he has significant stress and anxiety associated with his gender identity disorder. So yes, under the ADA, in accordance with this federal court ruling in Pennsylvania, you would have to consider going through the interactive process. The next trend that we need to talk about is parental leave policies. Now, there are all kinds of employers who are rushing out and creating all these very maternity-friendly type of policies where they're giving a very generous amount of time off work to their female workforce when they have a child. And all that is really wonderful. It is very noble. I wish it were there when I had my 4 kids. But I've got to tell you, the problem is that the news has picked up on this, and the media is only presenting one side of the story. And what the media tells us is, yes, you should adopt these type of policies, and you don't have to give anything to the dads because, they're the dads, right? Or you don't have to give as much time to the dads. Well, let me tell you that this can create a problem. So let's look at this fact pattern and see how this works out. George and Jane both work for you, and they just had twins, Judy and Elroy. You automatically provide your female employees with 16 weeks of paid leave upon the birth of a child, very generous of you. You also provide 2 weeks of paid leave to male employees upon the birth of a child. These paid benefits run concurrently with the time off work under FMLA for eligible employees. Now, George is furious, and he demands that he not have to just take 2 weeks of paid leave. He wants the 16 weeks of paid time off, just like Jane receives. He says that if you don't provide him with the time off work, he is going to call the EEOC. My question for you is, do you give George 16 weeks of paid time off, or do you call his bluff? Well, in June of 17, a father filed a systemic EEOC action with this exact type of fact pattern, and it was against a national employer who gave its employees a parental leave of 16 weeks paid time off for moms and only 2 weeks of paid time off for the dads. And the male in this charge filed an EEOC claim with the assistance of very capable plaintiffs' counsel, and the charge is still pending in Cleveland. And it is a systemic charge, which means that it seeks to benefit not only the particular father who's bringing the charge, but all male employees across the country who also have been subjected to this particular policy. And what the ACLU said about this particular charge was just amazing. They said, they put out a press release. Of course, you never want to be the subject of a press release by the ACLU or a national plaintiffs firm, but the press release said it was like something out of the 1950s. Just because I'm a father, not a mother, it shouldn't prevent me from being primary caregiver for my baby. This policy is outdated and discriminates against both moms and dads by reinforcing the stereotype that raising children is women's work and that men's work is to be the breadwinner. Now, again, remember, this is still pending in Cleveland. However, this year, in July of 2018, we really had this message brought home to us in the form of a settlement that the EEOC reached with a retail giant, a national retailer. And the settlement, the retailer had to pay $1.1 million because it offered 6 weeks of paid leave for bonding for mothers on top of whatever was medically necessary and covered by short-term disability, 2 weeks of paid leave to fathers as secondary caregivers, and 4 weeks of transition back to work benefits, which meant that the person could work from home, maybe come in late or leave early, or use compressed work weeks where perhaps they only worked 3 days but longer days. And this type of transition back to work benefit was only available to mothers and not to fathers. Again, the EEOC settled this case for $1.1 million. That is not where you need to be, so you might say to yourself, so how do I avoid that problem? Well, here are the rules. Regardless of what you read in the media, this is what you have to follow. First, leave related to pregnancy, childbirth, or related medical conditions can be limited to women affected by those conditions. But we have to be very careful for purposes of avoiding sex discrimination claims under Title VII that we distinguish between time off that's necessary related to the physical limitations imposed by the pregnancy or the childbirth. So maybe I need time off work, for recovery after the birth. You have to distinguish between that and leave for purposes of bonding with a child or providing care for the child. So, if you go to your doctor and, you've just delivered a baby, you're going to have follow-up times, appointments with your doctor. And maybe for the first 6 weeks or 8 weeks, maybe the doctor says, look, you're not medically able to work yet. However, at some point, the doctor's going to say, yeah, you're medically able to work, but you're still going to be asking for time off work, right? At least under family medical leave and perhaps under a policy. It is that additional time off work to bond with the new child or to care for the child that has to be provided to both men and women on the same terms. So if you provide 4 weeks of bonding time to mom, paid, then you have to provide 4 weeks of bonding time to the men, paid. When you're trying to create one of these policies, or perhaps you're checking your own policy, you want to make sure that the mother's right to baby bonding leave isn't diminished by her pregnancy disability leave. So again, you've got to have these hard stops between the time that she's medically unable to work, and the time that she's able to work but is taking off in order to bond and care for the newborn. The best way to create a hard stop there and a nice line in the sand is to make sure that you're getting a doctor's note to confirm the period of pregnancy-related incapacity, right? That way you know that up to that point in time, you can treat mom as well as you want. You don't have to worry about how you treat dad, okay? But once you clip that line, then again, the additional time off work, if it's paid, whatever the benefit might be, it has to be offered to men on the same terms as women. Now, one thing that employers are trying to do, and certainly in this national case that got settled with the EEOC, the employer tried to differentiate benefits based on whether or not the employee was the primary or the secondary caregiver. And there's nothing per se unlawful about that. However, the problem is that, for instance, in this particular case, there was evidence that the third-party administrator of the parental leave benefits plan was steering employees. So if you were a guy and you called and you said, hey, my wife's about to have a baby, and I understand that we have a parental leave benefits policy, I'd like to apply for benefits, the TPA was steering those men into the designation of secondary caregiver, so they would automatically get less benefits. So if we steer employees into different designations or we make assumptions about designations, that's unlawful. The only way really to get around that is if you ask employees to identify the primary caregiver. And while you can ask till your heart's content, of course we can't control whether or not they're honest with us. And think about how tough it would be to challenge somebody, perhaps a woman who says, no, I'm not going to be the primary caregiver. My husband's going to be the primary caregiver, right? So how are you going to challenge that? So you have to make sure that if you're going to use these primary and secondary caregivers, that we're not steering or assuming or we're not doing something that might naturally cause the men to all fall into the secondary caregiver role as opposed to the primary caregiver, because who knows, maybe you'd wind up running into somebody like me who has 4 kids and my husband is the primary caregiver. All right, tip number 4. So here's a fact pattern. It's easier to discuss in the context of a fact pattern. Your family medical leave, short-term disability, and long-term disability benefits are administered by the same third-party administrator. And they send you notices when employees are approved or denied for family medical leave, and they review and approve all short-term disability and long-term disability paperwork. The employee, Catherine, requests and received 12 weeks of family medical leave. She also applied for short-term disability benefits through your group plan. The TPA sent Catherine a letter 2 weeks ago reminding her that she would exhaust all of her family medical leave on Monday, that you, the employer, would expect her to return to work on Tuesday, and that if she couldn't do so, she would need to apply for an extended leave of absence. Catherine didn't return to work on Tuesday, Wednesday, or Thursday, and she didn't contact you, her boss. You have a 3-day no-call, no-show rule, and you ask the third-party administrator, you say, hey, do you have any information regarding Catherine's status, so that I can understand why she didn't call or show up for the past 3 days? And the TPA promptly says, well, I do have that information, but I can't tell you because it's protected by HIPAA. Can you terminate Catherine for her no-call, no-show? Now, if your TPA had given you the information that you had asked for, what you would have known is that your TPA told Catherine last week that she was approved for continued short-term disability benefits due to her continued incapacity from her cancer, that according to this TPA's letter, Catherine's condition was expected to continue for an additional month, and her short-term disability benefits were extended for that additional month as a result. Catherine was directed by the TPA to provide additional medical information if she was unable to return to work at the end of that 1-month period. Now, you can see, of course, if you're Catherine, how confusing that might be, because your TPA is just telling you, hey, I've got your medical information, we're approving your short-term disability benefits for an additional month, but yet you've also been told by the TPA that you, Catherine, have to get back to your employer if you can't come back to work at the end of your 12-week family medical leave. So if I'm, the employer, I represent the employee, I'm going to say, whoa, I just relied on what the TPA told me. The problem is, if your TPA is relying on the HIPAA privacy rule, they're precluding you from getting information that you need in order to assess whether your employee requires an accommodation under the ADA. And most TPAs completely innocently think that the HIPAA rule applies and prevents them from providing you this information, but it doesn't. The HIPAA privacy rule only applies to health plans, healthcare clearinghouses, and to any healthcare providers who transmit health information in an electronic form in connection with transactions for which the Secretary of Health and Human Services has adopted standards. Since employers generally aren't covered, the privacy rule doesn't protect the information in an employer's employment records, even if the information is health-related. So let's pretend as though you didn't have a third-party administrator of your short-term disability benefits, and instead you have another coworker in the office next door to you who takes care of your short-term disability requests. Well, certainly the company would be charged with the knowledge that your coworker has as she manages your short-term disability benefits plan. It's no different if the TPA has a knowledge of that because they're your agent. So all the information that your TPA has is considered to be your information. And when the TPA says, no, you can't have that, in most situations, unless you fall under the definition of a health plan, healthcare clearinghouse, or healthcare provider, that HIPAA rule doesn't apply. So you've got to make sure you're checking those silos. And by silos, I mean, little shoots of information that your TPA might have to ensure that they don't have information that you need to make good, reasonable accommodation decisions. And while you're at it, you should also check with your workers' comp third-party administrator. Many employers have those. And in the context of the ADA, we often have situations where the person is receiving workers' comp benefits, they're receiving family medical leave, and at the end of their FMLA, they still can't come back to work. And you're wondering, oh, what's going on with this person? Where am I? Do I need to be reasonably accommodating their continued incapacity to work? You may have information that's in the hands of your workers' comp third-party administrator. And unless you go get that information, then you're going to be charged with the knowledge of it, but you won't have it and you will make bad decisions. So check for silos with your workers' comp TPA and also check for silos with your managers, because I can't tell you how many times I've been on the phone with an HR executive and we're talking about terminating somebody for whatever the reason may be associated with their leave of absence. And I say, are you really sure? Have you checked with the frontline manager to make sure that, they haven't gotten anything, maybe a text message, maybe something through Facebook? It could be anything, but you really need to go check with your frontline manager. And inevitably, the HR rep says, no, I'm sure he hasn't gotten anything because he would have told me if he had. So I say, well, why don't you go get that manager and bring him into your office, and let me just ask him a couple questions. Within 2 or 3 minutes, we find that HR manager, they were receiving texts, on a regular basis from this employee, and he knew that the person was continuing to suffer from whatever the disabling condition was. So what is that? Information you're charged with. Again, unless you check those kind of silos where information could be stuck, you'll be charged with the knowledge, but you won't have the benefit of it, and it'll cause you to make bad decisions. All right, trend number 5. Do legal marijuana users get a pass on drug tests under state law? That's the question that's being bantered about in the courts. So here's the setup for it. So Barb just accepted an offer of employment at your new Massachusetts facility, conditioned on passing a drug test. She calls you and informs you that she can't wait to start working for you. She's so excited, but you should know that she has Crohn's disease and uses medically prescribed marijuana. So she's likely going to fail the drug test, and she will require an accommodation in the form of an exclusion from your drug testing policy. She tells you, don't worry though, I don't use it daily, and I won't use it during or before coming to work. You tell her you will consider what to do after she takes the test. She takes the test, and of course she fails. Your boss, when you tell him, says, fire her. We follow federal law, not state law, and marijuana is illegal under federal law. Do you rescind the offer for violation of your drug policy? Well, what you have to do is you have to check the particular state and the jurisdiction in which that employee is working, where it is that she took the test, right? Because the Massachusetts Supreme Court, and we've had at least one other court follow suit here, has found that essentially if you're prescribed medical marijuana and you are using it and you fail the employer's drug and alcohol test policy, then the employer can't use that failure against you. So in this Massachusetts Supreme Court case that came out last summer, the court said, the fact that the employee's possession of medical marijuana is in violation of federal law does not make it per se unreasonable as an accommodation. The only person at risk of federal criminal prosecution for her possession of medical marijuana is the employee. An employer would not be in joint possession of medical marijuana or aid and abet its possession simply by permitting the employee to continue his or her off-site use. So I'm sure many of you are going, wow, that's somewhat stunning that a court would not allow me to ensure that my workplace is free from drug and alcohol usage. But you have to put this into context. And again, you have to check for local unfriendly court decisions and state laws before you take action. Because right now we have 9 states plus DC that allow recreational marijuana, and none of those recreational marijuana statutes contain any language protecting employees or applicants if they test positive on a drug test. But we have 30 states and the DC that allow medical marijuana. And with respect to those 30 states, it's just like paid sick leave. Some of those state statutes provide protections to employees, some don't, some are somewhere in the middle. So you've got to look at each specific local jurisdiction and figure out whether or not there's a state statute that protects the employee, whether that state statute makes it illegal for the employer to refuse to hire or fire for using medical marijuana. Maybe it doesn't go that far. Maybe it just prohibits discrimination for medical marijuana users, in which case you're going to have to go through an interactive process. And then there are some states that are pro-employer, like Ohio and Florida, and they would allow the employer to make and maintain zero-tolerance policies and fire users even of medical marijuana. So the upshot of all this is you've got to check your local statute and your local courts before you refuse to hire or you fire someone for using medical marijuana. Regardless, though, please make sure that you're on the lookout for arguments that might be made for employees claiming that, well, you didn't fire me or you didn't refuse to hire me because of my medical marijuana usage. You did so because of my Crohn's disease. And, that's a lurking ADA claim that, at some point in the future we're going to see. The other thing that you have to be on the lookout for is, right now marijuana is illegal under federal law. If there is a change to the status of marijuana under federal law, then we'll have to reconsider whether or not we need to accommodate people. All right, here's the next one. This really should come as no surprise to you because, I don't know how recently you traveled on a plane, but I'm sure when you looked around, you saw more people with dogs on a leash than you probably saw passengers, or at least an equal amount, right? So everybody wants to bring their dog everywhere. You go on a plane, you go to a restaurant that has a little outdoor seating area, you go to different hotels. Everybody wants to bring and is bringing their animals with them to all these different venues. So does it really surprise you that we're seeing this incredible uptick of employees who want to bring their animals to work? And let's face it, it's so easy for someone to go through the process of getting some sort of a certificate that says that they need an emotional support or a comfort animal at work. In fact, it's so easy, and I thought this was great fun. I went out and I searched for one of the more popular certification websites, and I found this one, right? And I thought, well, let me see just how, just the steps and how hard it is to get a certification that says that I need to take my dog Ranger with me to work. So I didn't want to use my own identity because I knew that I was going to have to reveal that I had some sort of a psychological impairment, right? So instead, I used Margaret's, right? So I typed in, I said, I'm Margaret Fieldbinder. And yeah, I've got this kind of disability. And yes, here are my symptoms. And yes, I'm anxious. Yes, sometimes I'm nervous. Yes, sometimes I cry. Oh, look, in 5 more minutes and for a fee of $25, I can get a certificate that says that my dog Ranger gets to come with me wherever I want. Yeah, it's that easy. But don't worry, Margaret, I didn't complete the process. I did not push the send button, so nobody has any sort of negative information out there like that about you. But you can see just how easy it is. And so this is the situation that we're being presented with in requests made by employees to our clients and in the cases. So I'll give you 2 very different types of setup, and then I'm going to ask you a question. So the first setup is Charlie is an ambulance driver and a veteran who suffers from post-traumatic stress disorder. Charlie has a service dog who helps him control his anxiety and wake up from nightmares caused by his PTSD. Charlie asks to bring his dog to work with him at all times. The employer has a no pets policy. All right, so that's the first scenario. Here's the second scenario. Lucy is a concierge at a luxury hotel, and Lucy suffers from anxiety. Lucy has a comfort animal, a potbelly pig, who helps her remain calm and less anxious. She asks to bring her pig to work with her at all times. again, the employer has a no pets policy. So my question for you is, how do you handle that as the employer? Are you permitted to say to both Charlie and Lucy, sorry, no, we have a no pets policy. That means no dogs and no pigs. Can you do that? Well, many people think that they can make differentiations based on the kind of animal that the employee wants to bring. And this is a common misperception right here. So here's the way the law actually works. So the Americans with Disabilities Act has multiple different sections. And there's one section called Title I, and that's the section that deals with employment issues. There's another section called Title III, and that's what deals with public accommodations. So restaurants, theaters, professionals' offices, places like that, okay? Now, under Title III of the ADA, it defines a service animal as dogs and miniature horses that are trained to do work or perform tasks for the benefit of a disabled individual. Comfort pets and emotional support animals are excluded under Title III from the definition of a service animal. So if I go up to my favorite restaurant with my miniature horse in tow, and that miniature horse has been trained to assist me with some sort of a disability, some sort of task that I can't perform arising out of my disability, the restaurant has to let me and my mini horse come in. Now, the problem is that under Title I of the ADA, there is no definition of a service animal. And so emotional support dogs and comfort pets and comfort pigs and comfort peacocks and comfort whatever else you might come up with might arguably be considered reasonable in the right context. So under Title I of the ADA, you have to follow normal, reasonable accommodation and interactive process rules. By that, what I mean, if somebody comes up to you and they go, hi, I'd like to bring Pete, the peacock, with me to work every day, he's my comfort animal, you need to completely neutralize the fact in your head that this person is holding Pete, the peacock. And instead, you need to think of it, reframe it in your mind as he has just asked if he can have a larger screen on his computer, or he has just asked for additional break time so that he can make sure that he eats small amounts in order to control his diabetes. You need to neutralize whatever it is that he's asking to bring with him to work and follow the interactive process. Oh, okay, Catherine, so let me get some paperwork together, and I'll need some information from you, and we'll need some information from your doctor, and then we'll consider your request. And then in the letter to the doctor, it would be just like the letter you would send asking for information to support a request for that larger monitor or for time off work or for additional breaks. You know, does Catherine have some sort of a physical or mental impairment that substantially limits, you know, the language? Is there any portion of her job duties as described on this job description that she can't perform? If so, what is it and why? And how long won't she be permitted to perform it? Is there anything that I could do to assist her in performing the essential functions of her job as described on the job description? Catherine has asked to bring Pete the peacock, her comfort animal, to work with her. Is there any reason why Pete the peacock would need to come to work with her? And if there is a reason to bring him, is there any sort of alternative accommodation that I might provide to Catherine instead of allowing Pete the peacock to come to work? Because in my workplace, here are the things that are going to happen. So you send that employee that letter, you have her doctor complete it, return it to you, you consider the information, and you engage in the back and forth to determine whether or not the request to bring Pete the peacock to work is reasonable, or alternatively, it creates an undue hardship. Now, one thing that people miss, well, I guess this would be the second thing that people miss, is that, you know, under Title I, you've got these confidentiality rules, right? So if I come to work bringing my dog Fido, you can't tell people why Fido or why Ranger or Fido gets to come to work with me, but they don't get to bring their new puppy too. And you also have to consider the fact that there might be ancillary accommodations that you have to make for me if I get to bring Fido to work, because clearly Fido is going to have to take meal breaks, and Fido is going to have to go take breaks in order to relieve himself. So those will raise wage and hour issues and undoubtedly cause questions among your group, which you're not going to be permitted to answer. So the next trend that we have to talk about is how outdated job descriptions just continue to curse and create unnecessary problems for employers in the case law. Here's the setup. Sue is one of the in-house counsel at your company. Sue is pregnant and has requested permission to work from home for 10 weeks while on modified bed rest due to pregnancy complications. Sue's doctor's note says that she's prohibited from prolonged sitting or standing and heavy lifting. However, she can work while on bed rest. Your job description in a recent email from the general counsel, Sue's boss, says that due to the nature of the job, all the in-house counsel must be present at work during normal business hours to handle legal questions as they arise, unless they are attending hearings, depositions, meetings, etc. Sue, when you tell her this, explains that, wait, I and others in the legal department have frequently worked from home, even for extended periods of time for a variety of reasons, and it's never been an issue or caused any problems. We're all able to get our work done. Can you deny Sue's request to work from home for this 10 more week period? So this case actually came up here in Cincinnati Federal Court. And unfortunately for the employer, they told Sue no. And the Sixth Circuit Court of Appeals said, I'm sorry, that was the wrong answer. And what the court said was, look, telecommuting in this particular case would have been a reasonable accommodation for this in-house attorney because in the past, the attorney has worked from home without issues, as have other people. It's only for a limited period of time. And just because there's a job description that says that she needs to be at work, that doesn't necessarily make it so. And in this particular case, the employer actually made the decision that there was no way that they were going to allow Sue to work from home while she was on bed rest for 10 weeks. Instead, they were going to give her family medical leave and short-term disability. And then, when she was off bed rest, she could come back to work. That, of course, was not the same as allowing her to work from home because she gets less money if she's on FMLA or STD. And so that doesn't diminish the reasonableness of the request that Sue is making. And in this case, the employer lost. So, the rule for you here is, in this case, the job description really did not match what went on at work. And it was for a limited period of time. Perhaps if the job description had been more clear about why Sue needed to be at work, or, the limited amounts of time that people could work from home on occasion, maybe that would have saved the employer. I'm not sure, but certainly their outdated job description did nothing to help them. There have been other cases recently that follow along the same lines. We recently had one where a police officer said, look, I've got this medical condition, and my doctor says that I can only work 8-hour shifts instead of 12-hour shifts due to my condition. And the employer said, no way, you know that everybody always has to work 12-hour shifts. That's an essential function of the job. And so they denied the accommodation. Well, unfortunately for the employer, the job discrimination for the police officers did not say that the officers had to be available and, in fact, work 12-hour shifts as an essential function. Had the job description been accurate, perhaps the outcome of the case would have been different. We had a scary case that came out a couple of weeks ago here in the Sixth Circuit. And in that case, we had a disabled human resources professional who brought suit after the employer provided 4 months off work and 2 months transition back to work on a part-time basis following the delivery of the child. And the employee asked that she be permitted to work a continued part-time schedule, and the employer said no. The employee and the coworker both said, look, she was only working a 50% schedule, but still she was able to get all of her work done while she was here. So, I think the coworker would say, and the employee in this case said, yeah, I was able to do all my work, even working a half-time schedule. And the court said, look, just because the employer's job description said that the position is a full-time position, that doesn't necessarily make it so. And in this case, the employer didn't tie the time and presence at work requirement to a particular aspect of the job. And even though the employee's boss might have found it very convenient if the employee had worked a full-time schedule, that doesn't matter under the ADA. Now, I think that this case was wrongly decided, but it is out there and you have to know it. And the upshot of it, or the takeaways, if you will, from it, are really in your job descriptions. in this particular case, the job description did say it was a full-time job, but the job description didn't go further and outline why it was important, why you actually needed to be at work in order to do the job. So had the job description contained that kind of detail, maybe again we would have had a different outcome. Here's the next trend that we're seeing, and that is ADA lawsuits due to accessibility problems with websites and applications that are available only online. So here's the setup. Your company requires all candidates for employment to apply through your website. Bonnie is legally blind, and she uses a screen reader to access information on the internet. Bonnie wants to apply for work at your company, but she can't apply through your website because your website hasn't been updated to allow people with visual impairments to access the site. Bonnie sues your company, claiming that you have discriminated against the blind by not allowing them to apply for employment. Does Bonnie have a claim under the ADA? Well, think about it this way. If you used a staffing company to help you source candidates or a recruiting company to help you source candidates, and the recruiting company or the staffing company said, oh, I'm sorry, no blind people need to apply, what would the answer be? Oh, yeah, that would be a problem, right? Same thing if your website is inaccessible and you require employees to only apply online. Now, we've seen this recent wave of class actions targeting businesses who have websites that are not fully accessible to visually impaired individuals. And if you're curious about whether or not your website has errors or has problems that would prevent visually impaired people from accessing your website, you can actually go to your home page, copy the URL address, and then go to this website, this wave.webaim.org/report. Put that in your browser, bring it up. There'll be a box where you can put in your home page, hit run report, and it will tell you whether or not you have errors on your website that make it inaccessible to people with vision impairments. So this, again, would only apply in the context of an employment matter to employers who require candidates to apply online through their website. And if you're one of those employers, or if you have a client that's like that, and you require candidates to apply online only, and that application section, or actually your entire website, is not accessible, then you've got a problem, okay? And so what we would say to you is, number one, your best case option is to go out and hire a consultant and get your website updated so that it's compliant with Web Content Access Guidelines 2.0 AAA. Or if you don't do that, then at least in the interim, put up a notice on your website, a general notice on your homepage and also in your application session that says that if you're having problems accessing the website, please call this number and we'll be happy to assist you. And don't give some general number. Make it a specific person and make sure that that person knows that when they get calls, they need to be returned, details need to be taken. And that way, if somebody calls and says, hi, I'm Catherine, I can't access your website because I have a visual impairment, if you're the person that's designated to take that call, you should be able to say, Catherine, I'm so sorry that you had trouble accessing our website. Let me provide for you a paper application that you can complete and return to me, or you can return it to any of our physical sites. That's the way you get around the problem while you are trying to get your website into compliance with the most up-to-date technical guidelines. The other trend that we continue to see, and this is really where we're seeing plaintiffs' counsel and the EEOC push the contours of the law, is in transfers that are denied without thinking, for situations where the employer doesn't even consider a transfer before they terminate employment for a disabled individual. So here's the setup. Joe's a Cincinnati dock worker returning from a 12-week family medical leave. His doctor has imposed permanent restrictions of no lifting more than 20 pounds, no bending, no stooping. Joe no longer meets the physical requirements of the job based on your job description. No dispute about that. But can you now end Joe's employment since no additional amount of time off work will ever overcome his permanent restrictions? Well, you always have to consider transfer to a vacant position prior to ending employment in this scenario. Now, you don't have to create a new position that doesn't exist. You don't have to bump an employee out of a current position, but you do have to consider reassignment to a vacant position as a reasonable accommodation. And the EEOC takes the consistent position that this is an accommodation of last resort. So in other words, this is what you do when all else fails. And the EEOC also takes the position that, in the case of Joe, the dock worker, when he can't come back to work in his old position because of his lifting restrictions, but he's generally okay if he didn't have to, or if we could observe these work restrictions, we would then, as the employer, we would reach out and we would find out what vacancies we currently have available, and we would determine based on Joe's job application or whatever we have in the file, whether Joe is minimally qualified to perform that job. And this is important because if Joe can go out there to Monster or Career Builder and find a vacancy at your company that he could perform, and you say, sorry, Joe, we don't have any vacancies, you're going to get sued, all right? And, if he has the minimal qualifications to perform the job, the EEOC takes the position that you cannot allow him to compete for that job against other potentially more qualified candidates, because if you force him to compete, it's like you didn't give him any accommodation at all. Everybody can apply for the job. So if he's disabled and can't come back to his old job, he automatically would be eligible to essentially accept a vacant position that meets his skill set and abilities. And that's the case regardless of whether or not maybe the new position is at a lower pay scale. That doesn't matter. So always make sure that you're considering transfers to a vacant position for disabled individuals prior to terminating employment. And that goes, the extension of that is if you're one of those employers who reserve light duty positions for employees who are injured on the job, you have to consider transferring those disabled employees into vacant light duty positions too. You cannot hold them aside for people who are receiving workers' comp benefits or injured on the job. So according to the Seventh Circuit case recently in late 2017, if you're disabled, regardless of whether the condition arose from an on-the-job injury or not, you have to be considered for one of those vacant light duty positions that would have otherwise been reserved for someone who was receiving workers' comp benefits. Same thing, of course, if you've got an employee who is unable to or who requires light duty because of her pregnancy. We know from the Supreme Court decision back in 2015 that if you have a pregnant worker who needs light duty restrictions, you have to treat her the same as any similarly situated other employee in their ability or inability to work. So if you're reserving those light duty jobs for workers' comp takers, you also have to consider the pregnant employee and the disabled employee for those vacant positions. Employers get that wrong all the time, and they get sued on a routine basis. All right, here's the next trend. Pregnant and breastfeeding workers who bring claims make incredibly sympathetic plaintiffs. And you just have to keep that in mind when you are handling their requests. So here's the setup for you. Mary is a floating administrative assistant who works in various offices to cover for other absent administrative assistants. Mary has just returned to work from a 12-week family medical leave due to the birth of her first child, and she tells you that she intends to breastfeed her baby and will need a private office or other location at each place where she's assigned to work with a door that locks so that she can pump breast milk. Well, the problem for you, of course, is that none of your offices or none of your workplaces have private offices with doors that lock. So can you tell Mary that she'll just need to use the employee kitchen wherever she's assigned to work, and if it's vacant, great, but if not, she'll have to go to her car to pump? Now, I just said that, and that hurt your ears, didn't it? So this is a natural, oh, that doesn't sound right. And on this one, you got to follow your gut, right? Remember, Mother Nature, like the old, Parquet butter commercials or margarine commercials, Mother Nature is no fool. You will get in trouble here if you don't try to be creative and accommodate this person. And we've seen a lot of cases in this area. And under the scenario that I just gave you, no, you're not going to be able to tell Mary that, hey, just use the employee kitchen if nobody's in there, and otherwise go pump in your car. And here's why. So, we had a case in April of 2018 where the court in Tucson, federal court in Tucson, made very clear that denial of a suitable space to pump breast milk is the basis for a Fair Labor Standards Act violation, because the ACA requirements are that employers with 50 employees or more nationwide provide a space other than a bathroom, shielded from view, and free from intrusion for non-exempt nursing mothers for up to a year following the birth. So, if we tell her just use the employee lounge, even though the door doesn't lock, we need to figure out a way so that we can prevent intrusion into that employee lounge while she's breastfeeding, or pumping. And we certainly can't say just go to your car and pump. We are obligated to provide that space that meets all those criteria. We also had a case late last year where an employer, a police department, had an officer who was out on the beat, and following the birth of her child, she wanted to breastfeed. But of course, as a street cop, she had to wear a bulletproof vest. And her doctor said, well, when you wear this bulletproof vest, it's so tight that it interferes with your body's ability to produce breast milk. So you need to ask your employer for an accommodation in the form of a desk job while you're still breastfeeding. And she made that request, and the police department said, oh, heck no, but here's what you can do. You can just, we'll give you a looser fitting vest. And of course, what's the point of a looser fitting bulletproof vest, right? So, when she said, no way, man, that thing doesn't fit, that's not going to protect me. And he was like, the employer was like, oh, just don't worry about the bulletproof vest then. Just, I'm not going to give you a desk job. You're going to have to go out there, either wear the loose vest or don't wear one at all and take your chances. Of course, again, that's the kind of explanation that hurts our ears. And the court said, look, employer, you really screwed this one up. You failed to accommodate this person. And so therefore, you're liable under the Pregnancy Discrimination Act. Also, keep in mind that there are state and local laws requiring employers to provide accommodations for breastfeeding and pregnant employees. So make sure you're reviewing your policies, your procedures, and your practices. Make sure that whomever it is that's in charge of receiving those type of accommodation requests for breastfeeding and pregnant workers really, really go the extra mile in terms of trying to find a creative solution to the problem, because again, this is an area where the pregnant and the breastfeeding new mothers are really just kicking employers' tails in the courtroom, and you don't want to be in that position. So if you'd like to stay up to date on new developments in the area of the ADA, family medical leave, and generally leave management on the state law level basis, please do sign up on our website for our disability leave and health management blog. It's a free service. You'll get updates whenever there's a new notable case. You'll get practical guidance. And also, for those of you who have HR reps or HR professionals who are in the Cincinnati area, the greater Cincinnati, Northern Kentucky area, every year our Cincinnati office hosts an annual disability and leave management symposium called Leave It to Us. And there we have a half-day workshop where it's highly interactive. Folks, love to join us for that. We normally get about 200 people, and this year's annual conference is going to be held on October 5th. If you'd like more information about that conference, you can go to our website at that particular link, and you can get all the information that you need in order to register. Thanks so much for your attention. It's been my pleasure to talk to you today.
Thank you, Catherine. We do have a couple questions, so we'll try and get through them. Otherwise, if we can't get through all of them today, we will send you a follow-up email with questions and answers asked during this webinar, as well as the copy of the presentation itself and the recording. So what, Catherine, if you are a smaller employer not covered by FMLA, they provide 2 days of paid 2 days paid only for male and female employees whose spouse gives birth. What are they legally bound to provide on top of those days in Wisconsin?
Okay, so what we would have to do would be we would check the Wisconsin state law to see whether or not there is what we call a mini, that's M-I-N-I, FMLA law, because some states have state statutes that are like the family medical leave, except that they apply to smaller employers. So even though you're out of the box on family medical leave, we would need to check to see whether there's a state law that provides FMLA-like protection for the mother in this situation, or potentially for the father. And of course, FMLA and ADA is typically unpaid unless, of course, you offer some sort of paid time off benefit. So in this case, we would want to make sure that whatever paid time off benefit that the employer is offering after for the period after the mother is cleared to return to work would be offered to the father on the same benefits. So, the best course of action there would be to check Wisconsin state law, and also, make sure that we don't have a situation where we've got another state law or local ordinance that would obligate the employer to provide more time off to one or both of these employees.
Great, thank you. And this is a question regarding the service animals. What do you do if you have someone that has a service animal and you also have an employee that is deathly afraid of dogs? What do you do?
Yes. That comes up on a relatively frequent basis, as does the issue of what do I do when somebody says, I am so allergic to dogs, right? And what you have to do there is you do still have to accommodate the person that has the service animal, if of course they need the service animal in order to perform the essential functions of the job. And you may have to look at potentially relocating the workspace of the other employee who's allergic, or the other person who's deathly afraid of the dog.
And we'll take one last question. What are the best practices to handle reasonable accommodation requests and help employees during the process back and forth?
Sure. So the best thing that I can say to you is, number one, make sure that you understand what law applies during what period of time. Understand when family medical leave applies, when family medical leave ends, and when ADA applies. And, of course, ADA, when the 12 weeks is up under FMLA, that is just the beginning of the ADA obligation to accommodate. So you need to put in nice, strong processes, and certainly we help employers all the time create those processes for how you gather information. So as the employee is coming up towards the end of their FMLA period, or maybe you're a smaller employer and FMLA doesn't apply, we would help you with creating for you template letters that say, hey, Julie, we understand that you're scheduled to come back to work, or your family medical leave is scheduled to end on October the 30th. If there's any change in your ability to return to work, please let us know with as much notice as possible so that we can plan for your continued absence. And of course, if you believe that you are unable to come back to work because of a disabling condition, please let us know that so that we can determine whether or not there's any sort of accommodation that might be appropriate. Then you want to have a diary system in place where, if Julie sends in some sort of a new doctor's note, then you want to be getting information. It's a letter that you would send to Julie that says, hey, Julie, have your doctor complete this information so that we can determine whether or not you need a reasonable accommodation. And we have a template form that we start with, and then we tailor it a little bit, and the employee takes that, gives it to her doctor, gives it back to you. You then make an assessment, communicate to her back and forth in the undo process. And then we also have template letters, and this is really more of a toolbox, if you will, of templates. We have template letters that deal with the situation where the employee maybe says that they can only come back part-time, or maybe they have limited work ability, or maybe they need even more time off work. We have all kinds of letters that we help tailor for you so that you have a process to follow, even when you get to the point of, Julie's, says that she now needs a continued leave of absence, but she doesn't know how much more time off she's going to require. We have template letters that we create for employers and tailor those so that you can safely end the employment relationship without being in violation of the law. But it's all about process, and it's all about, thinking ahead of time as to what kind of communication pieces you'll need for your employees, and then having someone who's very, very knowledgeable in this space. So, you send them, to training like this, and so that they understand how this process unfolds. We walk you through it, we teach you how it works, and then you're basically armed and equipped to move forward with any accommodation requests that you get.
Wonderful, thank you. We are over time, but if you do have any additional questions, please feel free to reach out to myself, email them to me, or to reach out to your diversified or associated team. Thank you, Catherine, for sharing your knowledge on this very ever-changing subject. On behalf of Diversified and ABRC, I'd like to thank you for joining us. Just want to remind you that we will be sending a follow-up email with all the webinar materials. So thank you, and hope you have a great rest of your day.